Welcome to the Deep Dive. Today we're digging into something pretty fascinating, actually. It's a situation one of our listeners, Michael Troy Richardson, ran into.
Oh, really? What happened?
He got hit with a $1,000 citation in Utah, just for using the word engineer.
Wow, just for the word itself. That sounds strict.
Exactly. So we're going to unpack that, why it happened, what his arguments are against it, because he's definitely fighting it, and what this whole thing tells us about professional titles, regulations, and maybe even free speech.
Okay, sounds like a meaty topic. What materials are we working with?
We've got the citation documents from Utah, Michael's formal appeal, which is quite detailed. He lays out his case and even proposes changes to the law.
Okay, so we have his side clearly laid out.
Yeah. And for comparison, we have some stuff from California, their guidelines on engineering titles, which seem, well, different.
Ah, a comparative angle. That's useful. California often has its own way of doing things.
Right. And we'll also touch on the broader legal ideas, when government language itself might cross a line and be considered unconstitutional.
Got it. So the mission here is to figure out the why behind the citation, the arguments against it, and sort of the bigger picture implications for professional language and regulation.
Precisely. So for you listening, if you like getting into the weeds a bit, understanding how a single word can become a legal battleground, this should be really interesting. We'll break down the complexities without, hopefully, making your head spin.
Let's jump into that Utah citation then. Michael Richardson, you said?
Michael Troy Richardson, yeah. He has an ABET-accredited Bachelor of Science in Engineering Technology. Important background.
Okay, so a formal technical education.
Right. And he gets this $1,000 fine. His take on it is that Utah basically says using engineer means you're claiming to be a full-blown professional engineer, a PE.
Which requires passing the FD exam, 4 years under a PE, passing the PE exam, a whole process.
Yeah, exactly. Utah, according to him, just bundles the general term engineer with that very specific PE license.
That immediately strikes me as a potential issue, equating a common term with a specific legal status.
That's the crux of his argument. He thinks it's unconstitutional, especially given his degree. His first point is First Amendment commercial speech.
Okay, so he's saying using engineer is truthful speech about his qualifications.
Yeah, he argues it accurately reflects his education and skills. It's not inherently deceptive. And he's willing to clarify, use engineering technologist or something similar if needed.
That willingness to clarify is key, I think. It weakens any argument that he's trying to actively mislead anyone.
So the question becomes, is Utah's interpretation, this blanket ban, essentially narrowly tailored? Is it doing more than necessary to prevent deception?
That's the classic commercial speech test. Does the regulation directly advance a substantial government interest, and is it no more extensive than necessary? He's arguing it fails that second part.
He also hits on overbreadth. Is Utah's definition just too wide? Does it sweep up truthful uses of the term by people who have engineering education but aren't PEs and don't need to be for their jobs?
That seems like a strong argument. Think about software engineers, manufacturing engineers, roles where the title is common industry practice but doesn't imply PE licensure for, say, public works.
Could this law penalize them too?
Potentially, yes, if interpreted strictly. An overbroad law chills legitimate speech along with any potentially problematic speech.
Then he brings up the 14th Amendment due process, specifically vagueness.
Is the law clear enough?
Right. Would someone with his degree reasonably know that just saying engineer in Utah automatically means claiming PE status? Is that common knowledge or clearly spelled out?
If it's not clear, then it's arguably unfair. People need to be able to understand what conduct is forbidden. It's a basic fairness principle. Lack of clarity can lead to arbitrary enforcement, too.
He also touches on rational basis review. Okay, the state wants public safety, that's legitimate. But does equating all uses of engineer with PE status rationally relate to that goal, especially considering his qualifications?
Is it a reasonable means to the end? Or is it illogical, especially given his ABET-accredited degree, which signifies a certain level of technical knowledge? Could there be less restrictive ways to ensure safety?
Like regulating the practice of engineering requiring a PE, not just the word itself in all contexts.
Exactly. And you mentioned common usage earlier.
Yeah, the term is everywhere. Train engineers, sound engineers, software engineers. Utah's stance seems pretty divorced from how the word is actually used.
That's a practical point that also feeds into the legal arguments about vagueness and overbreadth. Does the law reflect reality?
And scope of practice. His engineering technology degree probably qualifies him for certain technical roles, design work maybe, that doesn't require a PE stamp for public safety projects.
Right. The PE is crucial for specific functions, often those involving public infrastructure or safety systems, but not all engineering work falls into that category.
And again, he says he's willing to use clarifying titles. He's not trying to hide anything.
Which, as we said, bolsters his case that the intent isn't deceptive. It's about accurately representing his expertise within the bounds of what's allowed.
So the specific laws Utah cited were 581, 501, and 502, unlawful and unprofessional conduct, and the penalties.
And the penalty seems to be based on this interpretation that using engineer is misrepresenting licensure.
It seems like the interpretation is doing a lot of heavy lifting here, not necessarily the explicit text of the statute defining engineer that way.
Which brings us to the comparison with California. How do they handle it?
It's quite different. California Business and Professions Code, Section 6732, distinguishes things. The general term engineer isn't regulated per se.
Okay, so what is regulated?
Specific protected titles. Things like professional engineer, licensed engineer, civil engineer, electrical engineer, mechanical engineer, even software engineer is listed as a title you can't misuse.
Ah, so they focus on the specific titles that imply licensure or a particular regulated field rather than the base word engineer.
Exactly. You can't use those protected titles without the license.
Yeah.
And you can't use the word engineer in a way that clearly misleads people into thinking you are licensed in those core areas, civil, electrical, mechanical.
That sounds much more nuanced.
Yeah, they have practice acts for civil, electrical, mechanical. You need a license to offer those services, and title acts for others like agricultural, chemical, software, where the title is protected, but maybe not the practice itself in the same way.
Interesting distinction.
Yeah.
And they also have title authorities.
Right, like structural engineer or geotechnical engineer. Those are restricted even further. You need to be a licensed civil engineer with additional qualifications.
So California has this layered system clearly defining what's protected and what's not, while Utah seems to have, based on this citation at least, a much broader prohibition on the single word.
It really sets up the whole discussion about when government language itself might be unconstitutional. Michael brings up several points, like vagueness.
We touched on that. Laws need to be clear. If they aren't, it violates due process, potentially allows arbitrary enforcement, like that old Jacksonville vagrancy law case, Papa Christus.
Right. People couldn't tell what was illegal. And overbreadth, too. We mentioned Reno v. ACLU. If a law restricts too much protected speech, along with unprotected speech,
it can be struck down, has to be carefully aimed. In this context, is Utah's law unintentionally hitting truthful speech about qualifications?
and obviously language that just flat out contradicts the Constitution, like defining press freedom in a way that kills it, is out,
That's fundamental.
then there's ambiguity.
Yeah.
If the government uses a word differently from common understanding without being super clear, like the FCC case with indecency standards,
It causes confusion and potential unfairness. Is engineer in the Utah statute clearly defined in this restrictive way, or is it ambiguous?
and this ambiguity, or overbreadth, can create a chilling effect. People might avoid saying something perfectly legal because they fear punishment under an unclear or overly broad law. Remember, NAACP button.
Absolutely. People self-censor. Could engineers in Utah, even those not needing a PE, hesitate to use the term accurately for fear of a citation like Michael's? It's plausible.
Finally, there's the idea of giving agencies too much power without clear legislative rules. Separation of powers concerns, like in the Schechter Poultry case. Is DOPL in Utah interpreting the law too broadly without clear direction from the legislature?
It's a valid question about delegated authority.
You know, all these legal ideas seem to really connect with calls for clarity in regulations, like Beverly Sauer's work on the rhetoric of risk, emphasizing precision.
And the Plain Language Act of 2010 mandating clear government communication.
Right. Michael's whole argument and his proposed fixes seem very much in line with those principles. He's basically asking for clearer, plainer language in the Utah law.
So what are his specific proposals?
He suggests Utah should specifically reserve titles that clearly imply licensure, like licensed engineer, PE. Make those the protected terms.
Similar to California's model.
Exactly. And then permit the use of engineer in other contexts, like describing your education, or in job titles where it's industry standard and doesn't imply PE status, like software engineer.
What about business names, like Smith Engineering Services?
He addresses that too. Allow it, but if the business isn't offering services that require a PE, they should have a disclaimer, making that clear.
That seems like a practical compromise, transparency without a complete ban.
He actually drafted sort of a mock opinion, like if this went to the Supreme Court. He argues they should partially uphold the Utah law's intent, but require revisions for clarity.
Revisions based on what?
Based on free speech, the Plain Language Act, and looking at how California and Nevada do it. Nevada, like California, apparently restricts specific protected titles, not the generic term.
So he's pointing to precedent in neighboring states.
Yeah, arguing Utah's broad ban infringes speech by stopping accurate descriptions of roles that don't need a PE. He says the current wording just fails basic clarity tests.
So rewrite it following the California model. Explicitly reserve licensed titles, permit non-licensed uses in recognized roles, clarify business use.
That's the gist. Then, focusing back on his own citation, his conclusion is basically, this citation isn't valid because the law it's based on isn't clear enough.
He's leaning heavily on the Plain Language Act.
He is. He says the law demands clarity, conciseness, no ambiguity, and Utah Code Section 5822-501, as interpreted, fails to clearly separate PE from general uses of engineer.
And his requested ruling on the citation itself.
Withdraw the penalty. He argues the enforcement is unclear, inconsistent with how things work elsewhere, and the law doesn't meet PLA standards. Utah needs to fix the statute first, align it with California and Nevada, make that distinction crystal clear.
It's a coherent argument. The law is flawed, therefore the citation based on it is unjustified.
And finally, he filed a formal request for a hearing, contesting the citation number, denying wrongdoing.
On what grounds specifically in the request?
Pretty much summarizes what we've discussed. Statutory overreach compared to other states, violation of the Plain Language Act's clarity requirement, and lack of just cause, which harms his professional rights and has that chilling effect.
And the request asks for
a formal hearing, reconsideration of the citation considering these arguments and precedents, and ultimately full dismissal.
So he's pursuing all the formal channels to challenge this.
Seems like it. So wrapping this up, this deep dive really shows how complicated something as simple as a professional title can become, right? Michael's case in Utah is a perfect example.
Absolutely. It brings together freedom of speech, due process, the need for clear laws, principles like the Plain Language Act, even ideas about risk communication.
And that comparison with California really highlights that there isn't just one way states handle this. Utah's approach seems, well, less common perhaps.
It underscores why precise definitions in law are so critical. Vague or overly broad language can cause real problems for individuals just trying to accurately describe their work without necessarily protecting the public any better.
So here's something for you, the listener, to chew on. Think about the power of language in defining who does what. When regulations aren't crystal clear, who benefits and who loses.
And maybe, how can professional bodies and lawmakers do a better job of creating clear distinctions? Especially now, with technology evolving so fast and so many different paths into technical fields, what's the responsibility there to ensure clarity and fairness?
This Utah case, it's a stark reminder that the words we use to define ourselves professionally can actually become a battleground for rights and interpretation.
A fascinating intersection of law, language, and professional identity.